Doc, need one. One run. 521. Start me a card for a parking problem. Foreigner 23. Yeah, we're all gonna 28 want truck when you're ready. Go ahead. One truck with Lincoln X-ray 985 should come back. Up next. So you had 2000 Patrick solving. 10-4. I think it's put a little note in something like that. I'll be leaving a note on the vehicle advising him to remove it.
Hey guys, I don't know why it's choppy like that. Hopefully that won't continue. Hopefully it won't come through when I'm talking to you guys. Good does not always triumph over evil, but given time, decency tends to triumph over indecency. It starts in our own hearts. None of us is perfect. There's corruption in each one of us. But if we're decent, we look in the mirror every day and try to overcome this, and decency wins more than it loses. In this fight against indecency over the last year, there have been a lot of really low moments. It feels alone. For the most part, even the witnesses who a few of us who've been standing up for leave us alone. They leave the fight for us. If the situation were reversed, would they fight for us? It doesn't seem to be so, but that doesn't change anything. It's still the right fight. Because when they aren't safe from unfair persecution, no one of us is. When they aren't safe from grifters who stir up mobs for their own personal benefit, no one is. Those that can't stand up against the mob, it's okay. We all do what we can. Everyone's situation is different. A couple of weeks ago, when someone was raising false smears against me of the most vicious nature, a friend asked me, is it worth it? Maybe it's time to get out. The cost is too much. Well, I thought about it, and I said right then on the phone, I said, a year or two from now, when all of this is a memory, I want to be able to look back at this day, at every one of the hard days in this fight, and feel like I did what I could, that I tried to be fair, tried to be generous and compassionate, that I stayed steady and did what I could. And it will never be perfect. Most times it won't even be good. But it's that day in the future that I play for. That day when I'll look back and hopefully I'll feel like I did what I could. All right, guys. So we have a lot of interesting stuff. I didn't really want to have to do a show tonight, but there's been so much interesting stuff that's come out this week and some of it today that it seemed like you kind of have to. So we're going to go over the last remaining mystery in this case, as far as I'm concerned, was the key cycles. Everything else was locked up. And now the key cycles are explained, and we'll go over that. In addition, there were new motions filed today that are fascinating. And they get into leaks in the Stoughton District Court and communications by the district attorney, and also some motions regarding the new vehicle testing that they want to do. So, and hi, Jeff. I saw that late before I had time to type hi, but thank you guys. Thank you, Mark. Lorena says that I failed. Well, only time will tell on that. And it's not just me. There are other people in this fight. And ultimately, it's whether justice and fairness and decency prevail. And I still think that they will. And I choose to fight using decency. Not because I can't fight dirty if I didn't want to or something like that, but because what's the point? You're just losing if you do that. You got to try to fight the right way. So this people send me dirt, I don't use it. If you have it on some of these people out there, the Glare, Turtle, the 13th juror. Yeah, I got a lot of great dirt on that stuff, and I have no interest in it. And I won't ever publicize it. It seems like the wrong thing to do. So let's just try to fight the right way. Let's get right to the documents. All right, let's go to the key cycles. Now, I know some people are going to say, this is boring. This is the last thing I want to go into is vehicle data key cycles. But it really is the last mountain to climb here. And it wasn't really much of a mountain, but now it's explained. So everything is all sewn up here. Really, the prosecution just has to go out and explain things. They need to do a better job explaining the injuries, but everything else it fits in so neatly to prove that Karen did this. Now, we don't know. When I say that, it proves the manslaughter charge. It doesn't prove second degree. That's always going to be there's different aspects of second degree, and the reckless endangerment part of just making the decision to go backwards in that environment for that length of time. We don't even know the whole length. We know at least 6 or 7 seconds she went in reverse, but then it goes off the data, so we don't know. But that's a long time to be going hitting the gas pedal 75%. So that would alone would qualify the reckless endangerment. But as a practical matter, a jury is not going to send someone to jail. You're not going to get 12. Let's put it this way: you're not going to get 12 jurors to agree that consists of malicious intent. Technically, it does, but no, there's going to be jurors that are going to be reluctant to want to send somebody away for the rest of their life if that's all there is. So what you need to ideally show is something else that shows an actual decision that could have led to John's death. Now that doesn't an intentional decision, and now obviously striking him on purpose or trying to scare him or something like that, I don't think there's any evidence for that. But if that's the case, that would qualify for second degree. But if she went back and if at any point realized what had happened but didn't immediately call 911, to me, I think that's pretty close. That would be second degree for me. I think that puts it over the top. All right, so let's get to the key cycles. We can come back to that stuff too. Hold on one second. Let me pull it up. Looks like I can't even make this big enough for me to read, let alone you guys. I can't expand this. That sucks. Yeah, sorry. You won't be able to read this. In fact, I got to open another version of it because I can't read it. All right. So I don't know the exact way that this was figured out. Supposedly there was some expert or somebody that in Finland that ran these diagnostics or looked at the data that was there and somehow said, I really don't know. And I don't care, to tell you the truth. It really doesn't matter to me. What matters is that there is an explanation. It makes total sense now, and the mystery is cleared up. Now, that will leave the problem, a very small problem, really, where Trooper Paul will have to get on the stand and explain that he made a mistake. That not on the essential data, no, but on understanding which key cycles were what. But it's as you'll see here, it's a very minor mistake. So the mystery was the key cycle during which John was struck was 1162. And the way Trooper Paul explained, now normally a key cycle would be when you start the car, you make a trip, and then when you stop the car, that's the end of the cycle. And then when you take the car out again, whether it's 15 minutes later or 5 hours later, it's a new key cycle. But the way he explained it at the trial, for some reason, the key cycle here, 1162, where the accident happened, were 3 trips on there. So he had the trip from the waterfall to Fairview and then back to John's house on One Meadows. Then a few hours later, Karen goes out looking for John. She ends up at the McCabe's and then comes back to John's. That's a second trip. And then the third trip would be when they go to Dighton. And in fact, there were also 2 other trips that for some reason he was unaware of. And that was the very short trip of the tow truck driver putting the car onto the tow truck. It was driven on. And then the same thing when he drove it into the Sallyport. So the way he had delineated it was that you had 1162. And then 1163, there's on the chart that he had, there's actually he doesn't show a key cycle. So he doesn't explain, was there no key cycle there or was 1163 something else? He didn't really explain. But then he says from 1164 and down, all those key cycles were made during testing. So when the vehicle was within police custody, basically by him. This doesn't turn out to be accurate. It turns out that 1162 was the trip when Karen went from the waterfall to 34 Fairview and to Meadows. End of key cycle. And within that was the accident. 1163 actually would have been the trip to go out searching for John. And then 1164 would be the trip to Dighton. 1165 would be the short trip onto the tow truck, and 1166 would be the short trip into the Sally port. Then 1167 would be where the testing begins in police custody. So we were trying to figure out this before. We've tried different theories. Could it have been the key fob? Could there have been a glitch with the system? But we were all going by Trooper Paul saying that the car was in police custody starting with 1164. But that turns out to be not the case. So obviously it'll somewhat impeach his credibility a little bit for Trooper Paul to have to explain to a jury that he had that incorrect before. But the key thing to remember is Trooper Paul is an expert on vehicle data, but he's not an expert on TechStream, which was the Toyota, the very particular program that was. So every car has a black box in it, and this produces vehicle data. Trooper Paul was trained on that. He trains others on it. But in Toyota and Lexus cars, they're owned by the same company, there is an additional system for gathering vehicle data called TechStream. And Trooper Paul didn't know how to use TechStream. He had to kind of learn during the course of this trial. He had never used it before, never trained on it. And ironically, I guess they could have hired ARCA to do it, because that's something that, according to their website, they're specialists in, even though they had no interest in getting that evidence here when the feds hired. But the state could have hired them, say, hey, come in and show us how it works. But in any case, it really didn't matter, because the key evidence, because of the way the key data in cycle 1162, because of the way it correlates with John's phone data, is what makes it so bulletproof. And there'd be no way for somebody to manufacture that. The idea they tried to send in, suggest in trial is that, excuse me, for example, that Trooper Proctor outside the Sally port drove the vehicle backwards at a high rate of speed. And that's when that data record was made, right? So you say, okay, when Trooper Paul is pointing at the vehicle data that shows it going backwards at 24, almost 25 miles per hour, well, maybe that was just one of the conspirators in the parking lot taking the vehicle and make it do that. This is why I'm going to tell you why that theory cannot work and doesn't make sense. It's because of the key correlation with John's phone data. Now, in the tech, normally with regular vehicle data, you're only going to get an event triggered. So what happens is the data is continuously streaming into these systems that are recording it and they're analyzing it. But they have limited memory, so they're not going to store a whole bunch of it. The only time they store it is if something triggers an accident, a collision report, basically. Usually it's a collision. And so then from the triggering moment, it'll record a snapshot of 10 seconds, a 10-second snapshot, 5 seconds before the triggering event and 5 seconds after. And that's it. So now TechStream, normally you only get this triggered event when there's a collision. Like a pedestrian collision, as the ARCA guys explained, would not normally trigger an event in the black box data because of the size differential between a human body and a vehicle. But TechStream is more sensitive and has a wider range of things that will cause the triggering of it to record an event. And that includes, as Trooper Paul explained, when she did the 3-point turn on Cedar Crest, which I'll explain in a moment, but because she hit the accelerator over 30% while in reverse, they've set the algorithm up. Bang. Okay, that's unusual. So let's create. So this system, now we start recording an event. Now, there were no triggered events in this Karen's vehicle for the entire operation of her car, the 2 or 3 years that she owned it, until this night, because she wasn't in any accidents and didn't do anything that triggered that algorithm. However, on Cedar Crest was the first. Let me backtrack. We don't know, and unless we get this new data, we'll talk about that a little bit later, where we don't know what time there were 2 events. We don't know what time they were, and we don't know where. Okay, so we only can deduce that by matching it up with the data on John's phone. So let's hold off on that for 1 second. So there are two events here. The first event is what looks to be a 3-point turn based on, you're moving the shift into reverse and drive, and you can look at that and say that's a 3-point turn. And the reason it was triggered was because she was hitting the gas over 30%. So probably because she was angry. Then 8 minutes and 4 seconds later comes another event. And this is the one where she puts it in reverse and more or less goes straight back for multiple seconds. Now, that one was triggered because, again, she was not only over 30%, she was actually hitting the accelerator 75%. And so, again, when the event is triggered at that moment where she is hitting the gas enough that it's creating an event, but now it goes back 5 seconds in time. So because it goes back 5 seconds in time to pick up that data, it actually picks up the first 3 seconds of her driving forward. Then she hits the brakes, puts it in reverse, and then slams the gas. And that's basically when the event was triggered, or a second before. It takes her a second to really trigger it. And then we don't know how long she went back because it only records 10 seconds. So it really only records 5 seconds after the event was triggered. And so we just know she was still going 23 miles an hour when the data ends. And she still had her foot on the gas. So as they tried to explain the trial, she never did stop. So obviously she stopped at some point, but within that 10-second vehicle data, she didn't come to a stop. So you have these two. So the collision, what Trooper Paul described as a typical signature for a pedestrian collision, took place 4 seconds into that triggered event. So, which is going to be 9 seconds because it starts 5 seconds before. So 9 seconds into this 10-second event, or 4 seconds after it was first triggered, that's when the two things that Trooper Paul indicated tell us that she struck a smaller object. One was the speed of the vehicle, despite no correlating lessening of the gas, dropped from 24.2 to 23.6 miles per hour. So that's only, a little more than half a mile an hour drop. But apparently that is standard for what you would see for a vehicle striking a pedestrian, which is obviously much smaller. In addition, at the exact same moment, the steering wheel was being held left, I think it was left 4 degrees. And at that second, it suddenly shifted to right 4 degrees. So it was a jolt. You can imagine you're backing up and you hit something. It causes, an involuntary jolt in your arm that changes how you're holding the steering wheel. So that's what we know about that data. So could somebody have recreated that? Well, yes and no. The reason it's going to be ultimately no is because of the correlation with John's phone data. So from John, now Karen and John driving to Fairview, they were, I think, about halfway there when they realized they didn't really know how to get there. So they called Jen McCabe up to get the directions again, or to get the address. And the address was 34 Fairview. So John opened up his Waze app, punched 34 into Waze, and then they got directions from there. And actually, at that point, they had already just missed the hold on 1 second, looking at the date again. That was I don't know exactly. They showed on the map. I don't have it in front of me, but they had already missed the turn onto Cedar Crest at that point. So they had to go a little bit further up, take a left turn, and then kind of come back that way. Waze will take you the most appropriate way. And so I guess we can pull this off since we can't see it anyways. So that was about 20 minutes and something into the trip. No, I'm sorry. That was at 12:20 and something seconds. I don't have it in front of me when John entered that into Waze. So it took him eventually to Cedar Crest Street, and you're taking a left-hand turn onto Fairview. Now but they missed the turn, maybe because it was dark, maybe because they were arguing, maybe because she's drunk, whatever, but they missed the turn. And you know how it is when you miss the turn, Waze will note that, it'll recalculate, and it'll tell you either to take a right or turn around or whatever. So we know the time that they missed that turn was at 12:23 and 46 seconds, I believe. So We know that because Waze noted it. This is, that's the moment that it recalculates. So she goes a couple houses up and then turns around, does a 3-point turn. That 3-point turn is the first triggered event in the vehicle data. So you have that beginning correlation right there. Okay. So now keep in mind, 8 minutes and 4 seconds after that is when the next event will be triggered. And 8 minutes and 8 seconds after that 3-point turn is when John will be hit. So now she comes to Fairview again, but coming from the opposite direction. Ryan Nagel is coming from the other direction too. So she has the right of way. She takes the right-hand turn onto Fairview. That's at 12:24 and 18 seconds. So if you put the 3-point turn in the middle, that would mean she took the 3-point turn at 12:24 and 2 seconds. Now, unless we get the new vehicle data, we don't. If it is known what time that turn was, it wasn't listed by Trooper Garino or Trooper Paul. So Trooper Garino listed. I don't know why it seems to me he would have those GPS points and know exactly or very close to within a second or two what time that turn took place. Maybe there's a reason he doesn't. I don't know. So it's. Let me just take this cough drop roll. So putting it in the middle puts it at 12:24:02. Again, clock is ticking. All right. So they take 34 is the second house on the right. They come to the driveway. Now, when you're in a dark area and you're looking for an address that you haven't been to before, you're probably driving a little bit slow. So what time did they pull up at the driveway? Your guess is as good as mine. But let's say 12:24:10. Does that sound reasonable to you guys? I don't, but we do know that she reached the far end of the property, which was 80 feet from the driveway. She reached that at 12:24:40 because that's the last GPS position of John's phone. So John's phone reached the far end of the property about 30 seconds. The turn was 22. So actually, no, it was only 22 seconds. So John's phone reached the far end of the property, near the property line, 22 seconds, only 22 seconds after they took the turn onto Fairview. Now that's in the data, and it's not fudgeable. Okay. So she didn't stop long. Now the Nagels, Ryan Nagel and the other people in the car, Ricky D'Antonio, I think testified that she briefly stopped there and then pulled up. When I say briefly, it had to be briefly because she had already reached the edge of the property 22 seconds after they took the right-hand turn. So let's say they took 5 or 6 or 7 seconds driving slow looking for the driveway. That only leaves, 16, 17, 18 seconds to get to the far end of the property. And she couldn't have been driving very fast to get there. So I don't think that really leaves time to drop John off. He would have to forget his phone on the seat. That's the only way. That makes sense. But let's say he forgets his phone on the seat and he decides to go into the house. He didn't have a lot of time to get into the house because she moved up. He didn't have a lot of time before she moved up to the far end of the property. So anyways, I don't want to get too lost on that. So let's look at the vehicle data again. So by 12:24, just to rehash, so around 12:24:02, that's when the first triggered event takes place, the 3-point turn on Cedar Crest. And by 12:24:40, they're already at the last position at the edge of the property. Well, what's 8 minutes and 4 seconds after 12:24:02? That's 12:32:06. So that would be the time when the next event in the vehicle data is triggered. In other words, that she's going in reverse at a high speed. Plus or minus, say 4 or 5 seconds, because we don't know exactly what time that 3-point turn was. It's 4 seconds further into that John was struck. So 8 minutes and 8 seconds. So if you take 8 minutes and 8 seconds after 12:24:02, that puts you at 12:24:10 as a plus or minus 4 or 5 seconds. That's the point when John was struck. Well, John's phone, based on the motion data, last moved at 12:32:16. Now that's bulletproof. There's no way around that. So, and we now, like I said, there's no way that Trooper Paul or Trooper Garino or Michael Proctor could have ever fudged that. Someone have to believe that they would know that data on John's phone showed that there was a 3-point turn on Cedar Crest, and they'd have to recreate all of that. That's crazy to believe in that. There are no geniuses, people, and it would take a true genius to even be aware of all that. And these investigations are all compartmentalized. So Trooper Garino is doing the phone data. Trooper Paul is doing the vehicle data. Someone else is doing this, and someone else is doing that. It's compartmentalized. That's the way these things work. It's not a bunch of guys sitting in a room thinking, how can we pull this amazing CIA level conspiracy off? It's just not like that. Even if that would have been possible to do that, there's no way they would have even thought of something like that. It's not reasonable to think it. One of the things in these cases is that, in any case, is often you're going to come to a fork in the road where it's either A or B. Okay, it's you come to a fork and you got to go in one direction, and that's part of a logic tree, right? And sometimes in these cases, both of those options are somewhat unlikely, and you're going to be forced to have to swallow one of them. Because if you're in a situation where it's either A and B, if it's heads or tails, you have no choice. Thank you, Frank. Appreciate it. So what you want to do there is choose the unlikely event that is less unlikely. Avoid the most unlikely one. And that's what you want to do. So I'm trying to think of an example. Let's say the O.J. Simpson case. It's kind of unlikely that the glove didn't fit, right? But there's so much other evidence in favor of guilt. I mean, blood everywhere. Blood in O.J.'s car. O.J.'s blood at the crime scene. The victim's blood from both of them in O.J.'s car and at O.J.'s apartment or his house. There's just so much evidence there, way more than anybody could plant, and so much other evidence anyway. So you're forced to accept the somewhat unlikely fact that the glove didn't seem to fit on the stand. And maybe you could explain in a way that his hands were swollen or the glove shrank or he was acting or whatever. But the bottom line is you still had to swallow something a little bit unlikely. But that's the reality of how it is in cases, because you're going to get to these forks where you're going to have to swallow something unlikely. And the way to make that decision is what is less unlikely. And that's just the way you're going to have to do it. So this vehicle data, there's no way to fake it. There's no way to fake the GPS data that shows that John's phone didn't go in the house. There's no way around these things. These are bedrock. These are bedrock things. So it's kind of important. So this is why I think when you get to the trial, Trooper Paul will have to explain that he misunderstood the key cycle aspect of it, but he didn't misunderstand the fundamental data which showed the classic signs of a pedestrian strike. There's no way that he could have fudged it. That data is still there. The defense can look at it. You can get any number of experts to look at it from any side. And it is what it is. It's not something that could be manufactured. And that was literally, for me, the last mystery of this. Maybe a close second would have been the cocktail glass pieces on the bumper. But I researched that way more than I would ever want to research that. But it turns out that matching glass is very difficult. At the end of the day, while they have a couple machines that the criminologists talked about on trial, they're not very they're not really good at matching whether a particular piece of glass belonged to another object. The only way that they really do it, the primary way, is through physical matching, which means you're taking this. Oh, I tried to hit show. Oh, I thought I accidentally deleted Frank's comment. The only way, it's like a big 3D jigsaw puzzle, basically. And who would want that job? I mean, that poor criminologist had to go over these glass pieces and try to do a 3D matching. Well, here's what they had. There were 5 pieces of glass found on the bumper. There were 9 pieces of glass found on the ground, and then there was the broken cocktail glass. So of the 9 pieces on the ground, 6 of them were matched to the cocktail glass. Now, that does not mean that the other 3 were not from the cocktail glass. They very probably were. They just did not find the physical match. Because there may have been other pieces missing that weren't found, and so that's why the physical match couldn't be found. As far as the 5 glass pieces on the bumper, none of those pieces were matched to the cocktail glass. However, one of the pieces was matched to one of the pieces on the ground that was matched to the cocktail glass. So 3 degrees of Kevin Bacon on the cocktail glass. 2 of the other pieces were found to be from a glass of that type, a cocktail glass of that type. So they couldn't prove that it was from that particular cocktail glass, but it was from something similar. And the other 2 pieces, they were not able to identify. But again, that's not this mysterious thing either. When you look into it, it turns out that a glass has a lot of, if you go, and really, if you just pick up any cocktail glass, next time you're at a bar, which if you're in Canton, you're probably at one right now, if you happen to be listening. So look at the cocktail glass on the bar, and you'll realize if you look at it closely, there's a lot of variance in it between the bottom of it and between the very top of the glass. It's, whatever goes into the blowing of a cocktail glass and the construction of it, the glass varies quite a bit inside it. So it's really a difficult challenge to definitively prove these matches, but there's no indication at all that glass was for something different. It wasn't colored different. It wasn't like, wow, we found a couple of pieces of red glass or green glass or something like that. So, there's a tiny bit of a little bit of doubt there, but there's always going to be that in any case. And the best explanation is that all those pieces were from the cocktail glass. That remains the best explanation. Let me get to Frank's comment, then we'll get to the motions. If this is a giant conspiracy, how do they know Karen would not come in? Would they have killed her too? Yeah, I mean, it's a good question. You can always ask these questions. And I think it's so important to keep asking questions until you feel like you, like when you feel like you get, till you feel that you have what is well beyond a reasonable doubt, that there just isn't any other reasonable explanation for events. And you do that by asking questions like this. And, you can say, for instance, if you're Jen McCabe and you're part of a conspiracy and the phone rings at 5 a.m., why would you take that call? Right. But you have to ask these questions in a both sides kind of way. So if you're Karen Reed and you knew you struck John, why would you drive back and then leave 5 angry messages? Wouldn't you, if you either you leave no messages at all, you leave deceptive messages, which kind of say, okay, John, I'm going to bed. I left some food for you in the fridge. They're not like that. So so you got to ask those questions. It's not just you can always ask not just what someone did, but why they didn't do something else. Those are important things to ask. And I think if the killers attack John in the house, there's so many aspects of this that don't make sense, and that will be one of them. How could they know that Karen wouldn't come back? Right? Why would the plan be to put John outside alive? Unconscious but alive, where somebody might save him. If they do, he tells the story. How could they know that Karen wasn't going to drive back and see John lying out there? Right? I mean, there's just so many aspects of this that don't make sense, but you have to keep running through everything from a both sides kind of way until you feel you have enough. And he continues, and Karen would do things to help them make her look guilty. Yeah, right. I think what he's saying there is he couldn't know that Karen was going to do all these weird things. Like the conspirators in the house could not know that Karen was going to call up Kerry Roberts at 5 o'clock and say, John's dead. He's hit by a snowplow. They couldn't have anticipated that, right? I mean, they couldn't have anticipated that Karen would be saying at the scene, if nothing else, saying, did I hit him? Saying those kind of things. They couldn't even anticipate it. How do you think they could have anticipated that Karen backed into a traverse and that's supposedly where she broke her taillight? No, I mean, it's just you run into absurdities everywhere you look on this. Everywhere you look. All right, let's get to the motion. And hopefully this motion will. Well, we have a few motions. I'm going to read the defense response to the telematics, and let's see how big we can get this. Huh. I wonder if StreamYard has changed something here, because it's not. I used to have an option of making it bigger, and I can take back in. All right. Can you guys read that? So I'm actually reading this for myself for the first time. I have not read this yet. But just to, in case people don't understand what they're talking about here. So the prosecution has hired a new independent forensic data expert who believes that now that there are upgrades available for the entertainment center chips, that they can get these things updated and then put them back on the car, and there's more data in there to be had. So for instance, we always wondered why wasn't there location data? Modern cars, especially a really nice car like a Lexus, is going to have a GPS chip built into it. So why couldn't they get evidence from it? So my understanding is this kind of stuff is connected to the entertainment system. And we saw in multiple motions before the trial that they were waiting for an update on the entertainment system software, and it just never came before the trial. But I believe what's happened now is that it's come in. Not 100% sure. We'll see what the explanation is here. But as we revealed a few weeks ago, they believe that they can get this chip, the software on it, updated, put it back in the car, and then get more data from the car, and presumably get all of the GPS with timestamps from all of her trips. So that'll really, I mean, if they get something like that. Well, here's the thing. This is why I called this the Karen test. I said this 3 weeks ago, that if Karen is innocent, she should be the most excited person in the world about this possibility, right? If she's factually innocent, then any new data is exculpatory. It's potentially exculpatory, and it's certainly not inculpatory. Any new data. She should be the one that's begging for this testing. And I said at the time, I said, if it looks like they're fighting this data, you'll know she's not factually innocent. And I would, based on so far, and I did read another one of the documents, and we'll play that one too, and we'll go over it. But that's the Karen test. So if they are trying to do everything they can to get this data, then that's an indication that she's innocent. But if they're in any way trying to object to this, trying to slow it down, trying to prevent it from happening, that strongly suggests that they're worried that this will show that she's guilty, because that new data. So for instance, how could it be exculpatory? I just went over how John's phone last moved at 12:32 and 16 seconds. And what if the vehicle data shows that Karen had left the scene by 12:28? Now, that doesn't prove by itself that she's innocent, because she could have, in theory, struck John and he staggered around a little bit before he stopped moving. There are different explanations for that, where it could show that she left at that time, but in fact, she is still guilty. But even though that might not be perfectly exculpatory there, it tends to be helping her more than hurting her. Because as it stands now, the evidence, the way the vehicle data correlates with the data on John's phone, as it stands now, it looks like she left the scene at 12:32 and maybe 16 seconds, 20 seconds, whenever she came to a stop and then turned around and went home. We don't know if she turned around or drove back towards Chadwick Street. My theory is that, has been since the end of the trial, that she was backing up because she didn't know how to get home by going forward. And she was really angry, punched the gas, and did a mad Evel Knievel kind of turn, 3-point turn somewhere around the driveway, and went back to Cedar Crest Ave, because that was the easiest way to remember how to get home, because it's just the way they came, and it's a straight shot. It goes right down to Dedham Street. Dedham goes down to Washington Street, which is that's Canton's main street, and then you take a quick turn onto Pleasant Street, which goes to John's house. So that's my belief, is that she didn't strike him on purpose, that she was just angrily trying to get home. But we don't know. We'll see what this data shows. This GPS data will show what route she took to get home, right? The defense is claiming that she went by the library, and that video was removed by the conspirators somehow, right? This vast conspiracy. All right, well, we're going to know from the data if she even went by the library. I don't think she did go by the library. Looking at the map, there's 3 basic routes that she could have went, and going by the library is only one of them. So she probably went one of the other 2 ways, and it's a motion-triggered camera. But we'll know if they get this new data. We'll also know if she went back to the scene of the crime. But if she didn't go back, so the state suggested to the jury that she was going back in the direction of the scene of the crime. But if we have that GPS data that shows she never went back to Fairview, that's exculpatory. That's good for her. So why wouldn't she want this data? She should, if she's innocent. All right, let's read the document. Now comes the defendant, Karen Reed. Scheduling, reassembly, and testing of defendant's Lexus telematics system. As set forth herein, the Commonwealth's new digital forensic expert, Shannon Burgess, has opined that there were deficiencies in the chip-off procedure conducted by the defense expert on the defendant's Lexus as a result of what he claims may have been programmer's error. Okay. As set forth herein, Reed objects to the Commonwealth's position regarding the new testing protocol as follows. The defendant vehemently disputes Mr. Burgess's characterization of the chip-off procedure conducted by Ms. Gaffney, which is based on Mr. Burgess's fundamental misunderstanding of the difference between a megabit and a megabyte. Now, we've probably, if you follow this argument on Twitter, so Karen's PR people, most namely Olivia, who Karen is always releasing documents to before they're filed, and this if you want to follow Karen's side, you will follow Olivia, and you'll see days, sometimes weeks ahead of time. You might even see material from Discovery. I didn't know that was legal, but I'm not a lawyer, but it's been going on for a year. But it is embarrassing if the state's expert made that mistake. I would say that's somewhat embarrassing. So how embarrassing, I don't know. That's like the kind of mistake that me and Tom Fleming might make. Bunch of boomers trying to mess around with megabytes and megabits. But even we know the difference, so I don't know. Ms. Reed respectfully requests that the court adopt the protocol proposed by the defense expert for any future testing of. So they have a different expert. Why, if the defense is confident in their first forensic data expert that did the chip off, why'd they get a new one? I don't know. I'm not saying it's suspicious. I'm just pointing it out. For any future testing, which properly accounts for Mr. Burgess's misunderstanding relating to the storage size of the chips in question, and seeks to prevent further mistakes by Mr. Burgess, which could result in the unnecessary destruction of evidence. So I don't know if he made a mistake in analyzing between bytes and bits. Is that an indication that he would make some kind of a physical mistake when doing the chip off that would result in the destruction of data? I don't know. So you have to look at his qualifications. He has a website, but I couldn't tell you if he's how good or bad he is. I have no idea. On October 11th, the Commonwealth filed a notice of schedule reassembly, blah, blah. So, all right, all the stuff we talked about. The request is premised on two opinions offered by Mr. Burgess regarding the analysis of the telematics and so the original chip off wasn't done until last December. And according to Burgess, it's incomplete. So there's more data that was not acquired. He says that the new hardware and software updates have been developed since the chip off was conducted in December of 23. Now, I do remember in all those old documents, and that's why they waited until December to do it. The state was consistently saying they're waiting for this update. And it's not like your iPhone when you're getting an update every couple of weeks. I mean, it's an entertainment system on your car. So it's apparently these probably happen every few years or something. So this defense expert, Matthew DeSogra, is a licensed professional engineer and certified IPC specialist with Delta Verse Forensic Engineering, has reviewed the chip-off work conducted by Mrs. Gaffney and opines that Mrs. Burgess misunderstands certain basic digital forensic concepts, including megabytes and megabits. I don't know if that's the only basis. But you'd have to look and see how many chip-offs has Burgess done. Just got to plug in my charger. Burgess. I'm going to keep saying it wrong. Sorry, guys. I always do that with names. And I went to, I lived in a neighborhood in Lawrence, Mass, where there was actually a lot of French Canadians. So I should know those names better, but I still screw some of them up. But not all of them. I can say LaCroix, for instance. Notwithstanding the fact Ms. Reed consents to a chip-off procedure for the sole purpose of determining whether any of the updated software or hardware may assist. All right, so here's the thing. All right, so here's what she agrees to. All right, so Karen agrees that they can do a chip-on procedure for the sole purpose of determining whether any of the updated software or hardware may assist in interpreting the data contained on the components in question. I don't know why they wouldn't just proceed to the upload. Now, they're going to say that if this guy's incompetent, that might destroy the data. But what are they proposing? I mean, do they have some proposal to get the data? Do they have a counter proposal? Let's see. In this declaration, Burgess incorrectly concludes that the defendant's digital forensics expert, Gaffney, failed to extract all the data. And I remember I read that motion live, and I have to go back and look at it, but I don't think that he reported it as though she failed. I think it was more just that there was not a software update, that they were waiting on the software update. Maybe I'm wrong. I don't know. I don't think he was in any way alluding to her being incompetent or anything like that. So, belief that the prior chip-off procedure resulted in 3 files totaling 8 megabytes in size when they should have been closer to 64, according to Burgess, in size, based on the total flash memory component of the chips in question. As explained in the attached declarations, Burgess misunderstands the difference between megabytes and megabits. I got to say, that would be really embarrassing if that's the truth. And it just, I wouldn't be shocked by it, just because nothing this state does ever shocks me. The incompetence of that first trial was shocking, to tell you the truth. And it's just grown more incompetent over time as I rewatched. And I don't mean that to be insulting to someone like Adam Lally, who seems like a good guy, an honest guy, and who did tremendous amount of work there. but it was incompetently run. Whether he was by him, if the problem was he had too much to do, there were bad decisions made before the trial began about how the strategy of how to conduct that trial. I'm not a lawyer, but this is just common sense shit. And the proof is in the pudding. You look in well, first of all, they didn't, despite having extremely powerful evidence, compelling evidence that should have led to a guilty verdict, they didn't get it. All right. So that's part of why I say they failed. But it's more than that, because you could make the argument, well, some of those jurors were tainted. All right, fine. But when I read the interviews that Turtle Boy did with the two jurors, I did not find those jurors to be unreasonable. One was a not guilty vote, and one was started out as not guilty, but switched on manslaughter. Sorry, I couldn't think of the name. He switched on manslaughter and ended up voting guilty on that, but he still clearly had some questions. But they both seemed like competent and reasonable people. None of them thought there was a conspiracy in the house, or at least didn't say that. They just felt the state didn't prove their case. And honestly, I know this sounds bad, but they were saying all the things that I was saying during the trial, that the state's not proving its case. And they were also affirming many of the things that I'm just a bartender. I'm not claiming to be any more than that. But they're saying the same stuff that I was saying for months before the trial, saying, if you do this, you will fail. If you don't do this, you will fail. You can go back and watch my episodes. I said it every show. I said it, and I said it even more strongly privately with people, a little bit more connected to things. It just was mind-boggling. So nothing really shocks me with this state. Nothing. And this is not this is an independent expert. So, but again, nothing shocks me. So 64 megabits is equal to 8 megabytes. Thus, Ms. Gaffney successfully acquired 8 megabytes of data from the chips during the December chip-off, which constitutes the total flash memory. That sounds reasonably convincing to me. But again, I don't know. I don't know exactly. It would be, that's too exact. That it's the exactness of that makes it seem plausible to me that the defense is right on that. But I don't know. Mr. Burgess's failure to properly record the total memory capacity of the components at issue could cause the Commonwealth to seek and perform unnecessary destructive testing. Well, I don't know about unnecessary. Look, because what good is, if you're not going to use this data before the trial, what's the friggin' point of it? So whether you're Karen or whether you're the prosecution, you want this data. So I would say that there's no worry about destroying it. It's not going to, what are you going to do? Save it to try to get a new trial or something like that? Karen, if you lose, it doesn't make sense. That data can no longer help you anymore. So if there's a question about the possibility that new data is there and whether this guy Burgess is actually competent, if there's any questions about his competency, go and get somebody competent. This time, get somebody else that's competent. Look, the prosecution, the new prosecutor Brennan made a key point in this motion filing for this new data, is that this data is expected to be either inculpatory or exculpatory. Like I said, it could help her or it could harm her, but it gives us a better understanding of what actually happened. So if there's any chance that data is there, that data should be there. Everybody that I've talked to doesn't understand why that they didn't have that data to begin with. So I think there's a pretty good chance that it's there, and it's worth making every effort to get it. Making every effort to get that data, even if that means you got to get rid of this guy Burgess and get someone who knows what he's doing. And again, I'm not saying he doesn't, but if he did make that fundamental mistake, it's troubling. So the software is called Burla for this. New and updated Burla software, which did not exist at the time Ms. Gaffney conducted. See, that's what I was saying. The initial chip-off could potentially assist in decoding additional information from the Lexus telematics system. As a result, Mr. Reed requests that the Commonwealth be permitted to conduct further testing with oversight by a defense expert. Okay. All right. So this is as far as the Karen test, she's passing it at this point. So her defense is saying, okay, let's get this data. Now, I think, it was going to look bad if they didn't say that, but let's give them credit. They're saying, let's get the data. The first step of any acquisition protocol is to properly record, inter alia, the memory storage capacity of the components the expert intends to test. The Commonwealth's expert failed to do that here. As explained in the affidavit, which is filed herewith, Mr. Burgess incorrectly reports the total memory storage of the components. This is getting repetitive, but so just skip through this because this is all about the memory. Mr. Burgess proposes that he perform additional chip-off acquisition attempts to ensure complete data capture. So this is the thing, you find with chip-off data. You also find this with DNA. The testing is destructive. So this is why both sides have to have their experts present for it to take place. So it's a very sensitive thing. If that data is lost, it's irretrievable. So, but, if I don't think it's as simple as, so let's say Karen knew that the data would harm her, so she wants it destroyed. Well, I don't think it'd be easy to find an expert to come in and destroy the data, because that damages his reputation. So, but you still have to have both experts there to make sure. This next part is hard to really. So perform additional chip-off acquisition attempts to ensure that complete data capture. This step is unnecessary because all available data was successfully retrieved during the first acquisition. In other words, the file size of the acquisition already matches the expected memory storage. However, Mr. Burgess should conduct an acquisition to ensure that the contents of the memory chips have not been altered by confirming the checksum of the chips in advance of any further testing. An alternate, this feels like a delaying. This feels like a delaying tactic to me. So what the defense wants now is they want the court to schedule a day when both sides will bring in experts, and all they're going to do is see if there is more data, but they're not going to get it. Then they'll go back to court and have to set up another day. It feels like a delaying tactic. Again, but it's hard for me to say. I'm not an expert in this, but to me, it feels like a delaying tactic, because if there is more data, then just get it right there. While you got your experts there, you bring your experts in, you see if there's more data, get the data. I don't see what could be more. I don't know, but maybe there's more involved in it, but the defense respectfully requests the defense expert be permitted to be present during any future testing conducted by the Commonwealth, and be permitted to temporarily halt any testing if Mr. Burgess attempts to engage in any testing which risks unnecessarily compromising the data at issue. Such as, I don't. The prosecution has no interest in destroying that data. So keep in mind, it is the prosecution that began this whole process of trying to get this new data, not the defense. All right, we get some exhibits. This guy, DeSegura, is from North Carolina, Tom Fleming. We'll have to send you in on a mission. Continuing education, blah, blah, blah. Let's see how long he's been doing this. So he hasn't been doing it that long. Not that means anything. Looks like he's been doing it about 10 years. All right, so let's bring in the next document. There's also an affidavit from this defense expert, but I'm not going to bring that in because it really just kind of was him saying more or less the same thing, but just in his own words. All right, now this one is interesting here. This case is going to continue to be precedent setting. There's so many aspects of this case that is going to be taught in law school. So much stuff between the involvement of the feds and First Amendment issues. We're seeing Fifth and Sixth Amendment issues coming up before the SJC this week. And we have the problem of spies, turtle spies. In this case, one that is in the Stoughton District Court, apparently. And this now brings Turtle Boy once again into the case front and center. So, all right, now comes the defendant, Karen Reed, and respectfully moves this honorable court to pursue, whatever that is, to order the Commonwealth to produce all communications made by the district attorney. Produce all communications made by Morrissey from his personal email address or cell phone that constitute material and relevant evidence in this matter, including but not limited to any communications with witnesses. In other words, statements of witnesses. And say in all ex parte communications with the court and or judicial staff concerning the matter. I'm sorry, and any all. So they want all. So they're accusing Morrissey of having communications relevant to the case and not making them part of the public record. As grounds for this motion, recent reporting corroborated by documentary evidence demonstrates that Morrissey had used his personal email address to communicate ex parte with Stoughton District Court personnel and judges in the publicly available email sent by Morrissey to Justice Stacey Fortes, copying to several other officials. Morrissey attached what appears to be a text message or iMessage sent to a member of the prosecution by a witness in this matter that constitutes a discoverable statement. So the witnesses were rightfully and understandably complaining about the harassment that they were facing, the organized, systematic harassment that was coordinated by the defendant, frankly. I feel comfortable saying that. Let me take a break. Based on evidence that's developing, yes, before we suspected that she had a heavy hand in it, now we know. But not going to say too much on it. This email and presumably a number of other communications that are material and relevant to Miss Reed's case are in the possession, custody, and control of the Commonwealth. And so they're trying to get Judge Canoni to order the Commonwealth to produce any and all communications by Morrissey that are discoverable under Rule 14. Now, I don't know if you want me to do a law school class here and read what communications are discoverable and what Rule 14 are. I don't know, and it's going to be explained in this document to some degree. So I'm not sure if it's worth it. I did read this document earlier, but skim through it. So Mark Betterow, Turtle Boy's strange little attorney, filed a letter with this court directed to Norfolk County District Attorney and former Judge Cosgrove. So this is the special prosecutor or the assistant helping out the special prosecutor of Turtle Boy for witness intimidation. In his letter, Betterow detailed communications between Jennifer McCabe and a yet unknown member of law enforcement, revealing that DA Morrissey had communicated on an ex parte basis with members of the Massachusetts trial. 1 second. Okay, so ex parte means from one party. In the legal context, it refers to proceedings or actions taken by one party without the presence or participation of the opposing party. This is typically an exception to the usual requirement that both parties be present in court proceedings. Ex parte matters often involve emergency situations where immediate action is necessary to prevent harm. For example, a person might request an ex parte restraining order to protect themselves from an abuser without notifying the abuser beforehand. So that actually does apply here, right? I mean, this was going on. What he was doing was bringing a mob down that is dangerous. I'm not going to try to exaggerate it like it's, I don't know, what's the danger? You know, it's not like a bunch of 20-year-old kids. You know, these people tend to be in their 40s and 50s, but they still created terror, and we're doing it on a regular, systematic basis with the witnesses. So, all right. So apparently, Jen reached out, it said, to an officer looking for help. Now, we also know that they reached out numerous times to Josh Levy, and he more or less ignored them. But what are they supposed to do? You try to do things the right way by using the system. If you don't use the system, what's left is to break the law and take things into your own hands. And that's what they've avoided doing. But the system has been unable to protect them, or really even to make a concerted effort to do it. I mean, they're trying. They did prosecute Turtle, but the harassment continues continuously. And, you know, these things, some of them involve gray areas of the law, but it doesn't seem to be a gray area when it comes to Kate Peter. If Kate Peter has her car surrounded and she chucks someone the bird, they're going to throw her in jail. It's a complete double standard. I don't know why it exists like that. I can't explain it. Some people seem to think it's just fear of this mob, but it's a cult. And there, as we saw a little over a year ago, when a 911 dispatcher was willing to run the license plate of a vehicle at the Proctor House, and it turned out to be Jen McCabe. And in that email chain, she's been fired because of this. So she lost, I think, 13 or 15-year career, lost all that pension, 18-year pension, something like that. And she was a Turtle rider, but she was nervous about doing this. She knew it was illegal. They know that. And Turtle threatened her. Said, you know what I'm going to do to you if you don't do this? Well, what he does is he embarrasses you in social media. That's what they do. That's what he's trying to do to Phelps this week. That's what they do. This is what I say, decency versus indecency. It couldn't be any more clear. It's not that everybody on this side of the aisle is 100% decent all the time. None of us are. We're all human beings. And it's not that everybody on the other side is always indecent, but the general indecency that goes on the other side is starkly different than what goes on this side. It's, you know, the constant blaming, smearing innocent people, either because they disagree with you, or in the case of the witnesses, because they saw something that Turtle Boy is making money. Listen, Turtle Boy doesn't give a shit about Karen Reed or about justice or about truth. It's money. It's money and fame and power, and that's it. And people feed that. So in this email, Morrissey sent from his personal email address while copying the first assistant's email address. The fact that Chris Albert, another witness in this matter, had sought an ex parte harassment prevention order. This is not going anywhere. This is crazy. Honestly, I can, now that I've reading this a second time. So it's not like they caught. All right. So in the Proctor text messages, he's talking about the case with high school friends and his sister. This is not that. This is Morrissey trying to protect witnesses who came in, but copying all of these messages to all the other attorneys involved. And I think the judge that was handling that at the time, Justice O'Malley. So there's nothing secret or dirty going on here. It's an attempt, but because it's an ex parte hearing that involves harassment, that's why it can't go to the other side. Look, if they sent this to Karen Reed's side, look what the scurrilous way that David Yannetti has acted since the beginning of this case. But just look at the trial. When, in order to disrupt Proctor, who was scheduled to testify on Monday, he schedules a meeting with Lucky Lawford in the parking lot of the elementary school where his sister works. And Lucky has said, we didn't even talk about anything. There was no, what was the point of being there? Yannetti falsely said that it was Lucky's idea to meet there. It was not Lucky's idea to meet there. And he never would have picked an elementary school. And even if you believe he did, which he didn't, David Yannetti he's a lawyer. He knows better, whereas Lucky might not, right? David Yannetti would know, no, you don't meet at an elementary school. That's going to cause a stir. And then he tries to say, I didn't know Courtney Proctor was in there. Come on. There isn't anybody that believes that. No, I shouldn't say that. We live in a state full of turtle riders, so they probably believe it. You think it's a coincidence that David Yannetti chose to meet Lucky Lawford in the parking lot where Courtney Proctor was working a couple of days before her brother was to testify? You think that was a coincidence? That's what David Yannetti wants you to believe, that it was just a coincidence. I had no idea that Courtney Proctor was in there. If you believe that, I don't know what to tell you. I do have a bridge. It's called the Bourne Bridge. It goes into the Cape, and I own it, and I'm willing to sell it to you for $100. But so anything that went to the other side, Yannetti's office, was going to go to Karen and then go straight to Turtle Boy, where it was going to be used to further intimidate these people in his blog and on his show. That's just anybody who doesn't understand that doesn't really know what's going on here and really hasn't followed this case. Mr. Abbott's affidavit in support of his harassment prevention order was improperly disseminated to a third party. The third party was what? The judge? They're trying to protect these people, and they knew that this could not be given to that unethical defense team, which was creating the very harassment that they were trying to stop. This is like similar to, let's say, three or four girls. Let's say three girls are, let's just say they're raped. Three girls are raped in the park by some guy in Worcester who likes a famous statue there, whatever. Three girls are raped by a guy in the park. And then there's a trial is scheduled. And then people working for that defense team of that guy charged with rape start trying to intimidate those three women because they're witnesses in the upcoming case. That's why the meeting is ex parte. That's why they can't be told. Because let's say that guy's out on bail. If he learns that they're scared and they went for help, that could have all kinds of effects. For one thing, it might change their strategy on how they try the case. But for even worse thing, it might encourage them to scare them even more. Or it might even lead. That's why it has to be ex parte. And so this is a similar situation. The very harassment. You know what? This is going to be a mistake for them to open the door here, because this is going to allow Judge Cannone to bring in what evidence they have, I believe, about Karen's involvement and, frankly, David Yannetti's involvement and Alan Jackson's involvement with this harassment. Turtle Boy launched his movement within a couple of weeks, was harassing these people. And in that time, he was speaking daily with Karen, and there were dozens of calls recorded directly between him and Alan Jackson and him and David Yannetti. They knew what he was doing. Look, I had a tiny YouTube channel, and in August, actually the end of July, Alan Jackson had Turtle Boy reach out to me saying he wanted to talk to me. I haven't deleted those. They're still on my phone. I never did talk to him. I messaged him and I said, I don't, I'm not sure what you're looking for. I don't have anything of evidentiary value. And I'm always going to, and I said, I'm always going to cover the case from both sides. And he said, no, that's okay. I just want to touch base with you. I'm going to call you in a couple of days if that's all right. I said, sure. But he never did. But why would Alan Jackson care about a YouTube channel that was getting a couple hundred people watching it live and might get, 3, 4, 5,000 views? But he did care. They were very, very closely watching YouTube and other social media platforms. They've used it more creatively than probably anybody else. And so they're aware that Aidan Kearney has been attacking and harassing these witnesses. They did, like I said, they did it themselves when they did the meeting at the elementary school parking lot. This is what they are. This is what they're about. It's a total ends justify the means thing. They're going to use every tactic they can. If they can disturb a witness, they'll do it. They'll do it. That's what they did to Proctor. Unethical, unbelievable what these guys do. Unbelievable. And that's why that's why they couldn't be in the loop on this. They couldn't be. So Morrissey appended a text message to his email from Jen McCabe saying, I know it's late, but I'm horrified that Chris didn't get it. And I'm even more disgusted that for the second time, someone from the court leaked it right away to Mr. Kearney. So this messaging that was going to them they're saying there was a leaker at the Stoughton court. Now, I don't know if they found that leaker, put a stop to it. Doesn't sound like they did. I haven't heard about anybody in charge with that. My impression of the courts in Norfolk County are that they're utterly inept. And I'm sorry I'm sure they're not watching, but if they are, yeah, you guys have a lot of inept shit going on in your court, in your offices. There's just too much. I'm basing it on the way that trial was done. And I'm sure if we look at other trials, we're going to see more of it. But my impression is ineptness. Even the Birchmore case, same thing. I don't believe there's corruption there. There may be, but I haven't seen any indication of it. But certainly ineptness, even given the fact that Farwell deleted his phone, still deleted his phone messages, and the feds found that in the iCloud. However, I don't know. The overall impression of me is incompetence. Prove me wrong. Get a win. So that incompetence probably applies to plugging leaks. It's the Three Stooges, maybe a little better than that, right? But have they plugged this leak? Is it one leak? We saw the 911 dispatcher, so we don't know how many leaks there are out there working for Turtle Boy. He can control people by threat of smearing them. What happens is somebody initially is drawn, some low-level worker is drawn to the idea of working for Turtle Boy. The mob has a certain appeal about it and wanting to be liked by this narcissistic leader and accepted as important. That has a lure to a certain type of people. And there's no shortage of them. But it's not that they're not necessarily an evil person or something, but they think they're doing the right thing and they don't realize they're just kind of following this need to be a part of something. But then once he gets his hooks into you, if he sees potential value because you work, for instance, as a 911 dispatcher, what is he doing? He's got the pit bull digging dirt on you. And they're digging dirt on you because they can use that to control you. Look, this not ingenious. It's easy to do this stuff if you're unethical, if you have no conscience at all. It's not ingenious. Everybody can say, "Oh, that's ingenious." No, it's easy to understand that you can control someone if you're willing to threaten them. If you have a mob that is willing to, when you say jump, they'll say how, they'll repeat whatever you say. They'll, when you have that and spread that through social media, the threat of social media destruction is probably now, it's more important. It's more terrifying to these people than losing their job, losing their pension, to many other things. The ultimate thing, people, and it's going to get worse because you look at kids now, their whole lives are like internet productions. It's all about taking pictures to put on your phone to show, this is my life. I'm going to this cool place. Everything is about social media. And so the threat of destroying them, you're destroying their whole world. And Turtle Boy knows he can control this. And like I said, it's not ingenious. It's just ruthless, and having ruthless people around you. And this is really the thing about narcissists. And I've researched it, but I don't think there are yet adequate explanations for it. But there's something about the narcissist that draws a certain type of people that are willing to dedicate their loyalty to that person. Now, I'm not talking about, like, say, Hitler, because that's a cause. People believe, the Germans that fell into that believed that they were saving Germany and restoring it. And obviously, at some point, that become wound up with the personal loyalty thing. But what I'm saying is that you take somebody like an Aiden. In normal circumstances, nobody's paying attention to that guy. Men, women, whatever. But now that he's got a microphone and he's so obsessed with himself and he believes he's daddy and he's the only thing that matters, there are people that are drawn to that and they're willing to kind of sacrifice themselves to that. I don't really know why. Some of these people do. Obviously, you look at certain leaders, like, say, a Jim Jones and his cult, they may have a certain charisma. He was a preacher. Same thing. You have the mic there, and he's got a crowd, and you start getting sucked in, right? He was preaching about things that sounded good to people, sounded like it was worth dedicating yourself to. So there were things like that. But I think there is something that's just about when you look at just the very worship of yourself that someone like that has, that will attract a certain percentage of the public. I don't really know why, but it's there. I think it's a real phenomenon that isn't fully explained yet, but that you'll get a certain percentage of the public that's going to hand themselves over to that. Maybe, one of the things, maybe it might be something like this. When you hand yourself over to someone else, it could be kind of free you up a little bit, right? It takes the weight off your shoulders of having to make decisions in your own life, of having to be responsible for yourself, for your own ideas. You just say, let daddy take care of it. And all I got to do is do my assigned job. And that's it. And make a lot of noise. Someone like Creepshow there, Haley, just going to attack other people. And so you get sucked. So when you see that person that all he is saying is, just listen to me. Don't think for yourself. Just listen to me. And anybody who opposes me, we're going to destroy them. I think there's a certain type of person that's drawn to that. There's no, maybe whatever it is, maybe 10% of the public, 5%. I don't know, but that's a lot of people. That's that, and maybe it's more than that too. I don't know. But I think there is a certain type of person that is willing to, let me just surrender it all. Let me surrender my ego. Every day you wake up and it's confusing and you got to figure out what's the right thing to do. How do you live your life? What am I getting up for? You just let that all go and you go give it to someone else. I think there's something appealing to that. But even that doesn't fully explain it to me. I think there might be something else. So Morrissey opined that the receipt of the affidavit in support, that's from Chris, in support of the harassment prevention order by a defendant in that very harassment order proceeding. So there was an actual proceeding. It seems like Morrissey did everything by the book here, actually. I mean, I don't know the book, so I could be wrong. But it seems to me that he did everything by the book. He had reasons to hide that from the defense. And not only that, it had nothing to do with anything of evidentiary value about Karen Reed. So Let's see, the legal standard. The due process clause of the Constitution require that the Commonwealth disclose to a defendant material exculpatory evidence in its possession or control. But none of that was exculpatory. None of it had anything to do with Karen. To be considered exculpatory and therefore subject to automatic disclosure, evidence need only tend to diminish a defendant's culpability. How does Chris Albert filing an affidavit that says he's being harassed and intimidated by the defendant's media people or minions, how does any of that have anything to do with diminishing the culpability of the defendant in a murder case? It has no connection at all. A prosecutor's duty to disclose extends to all facts within the possession, custody, or control of a member of the prosecution team. No, that doesn't, I mean, so are they supposed to give over their laundry list too? The prosecution team generally is understood to include prosecutors and relevant law enforcement personnel. Prosecutors' obligations extend to information in possession of a person who has participated in the investigation. This is not going to go anywhere. I don't have to be a lawyer to know that. This is just made for media consumption, like 90% of what this team does. On request, prosecutors also must disclose material and relevant statements of persons within their possession. None of this had anything to do with their activity as witnesses in the Karen Read trial. A statement is defined as a writing made by a person having percipient knowledge of relevant facts and which contains such facts, signed and otherwise adapted or approved by such person. So, I mean, if Chris Albert was witness to another crime outside his store, say, that had nothing to do with the Karen, let's say next week he is witness to another crime that has nothing to do with Karen Read, nothing even to do with his store. He witnesses a car accident and he signs an affidavit about what he saw. Is there an obligation to give that to Karen Read's defense team? No. Any victim or witness statements in possession, custody, of control of an advocate are subject to a discovery order. I mean, victim or witness statements. I mean, the statements have nothing to do with the defendant or what the testimony of nothing to do with the defendant relevant to the trial for murder. Yeah. So they say that Morrissey's communications are within the possession, custody, and control of the Commonwealth. Yeah, he sent them out to everybody. It was nothing secret about it. Everybody that was relevant to the attorneys and the judge. This stuff seems, they talk about work product. All right. I'm going to actually stop going over this document now. I'm bored with it, and I think it's crazy. So let me take this out. Let me look and see if it seems like there was some other documents this week. Let me make sure there's nothing. It's always been a busy week, and then you're like, some things can't be discussed. So there was a motion by the prosecution to get the first recorded interview with Gretchen Voss. The Commonwealth was provided a 3-hour and 19-minute recording for this interview, but the second recorded interview occurred on July 23rd. And then they got that. But then there was a third interview with Voss that was not recorded. During the unrecorded third interview, Voss took notes. I thought they already aired this out last year where they tried to get, she didn't want to give up her notes and the judge didn't force her to. The audio, this is interesting. So the audio recordings provided are saturated with redactions. The June 20th audio was riddled with approximately 50 redactions. The July 13th audio was marred by approximately 100 redactions. Many of the redactions occurred during discussions and admissions pertaining to critical issues in this case. Many of the redactions include interjection by the defendant's attorneys. So when she did these interviews with Gretchen Voss, David Yannetti was with her. Amazing that he allows all this to go on. I don't really understand. This guy's an irresponsible attorney. I'm sorry. Because her words are causing her words are there in the public all the time in order to try to stir up a mob that will pollute the jury pool. However, they're causing a problem. This is why the prosecution is trying to get him and also trying to get her her TV interviews, get the unedited footage, because she's changed her story a lot. And there's a lot of stuff in the story, and I can definitely in the Gretchen Voss one that contradicts even what Alan Jackson was trying to say in his closing arguments. I'm not going to say more about that, but so also at Purdue's Department of Computer Information Technology, the guy's name is Umit Karabiak. Vanity Fair says he specializes in iPhone artifacts and the limitations of digital forensics to evaluate the prosecution's expert testimony, as well as an affidavit from Reed's expert. Specializes in iPhone artifacts and the limitations of digital forensics. So this sounds like a guy that generally is trying to argue for defendants and saying this information doesn't show necessarily what you think it shows. But ironically, he said the opposite in this case. And they have it in quotes. He said, based on my research and expertise, I concur with what I see in the affidavit from Richard Green. So he was only sent Richard Green's affidavit. And then we've seen through the great work of Tuesday Gazette that the Vanity Fair writer told him that the prosecution disputed this and had their own independent expert to dispute it. She did not provide an affidavit from the prosecution expert. I'm not even sure if there is one, but they testified. And he apparently did not seek out the testimony of Ian Whiffen or Jessica Hyde for this article. So he tells them that though the browser tab was opened earlier than the searches, the timestamp for the search items is recorded for searches and stored in the database, not the time of the tab opening. So he's basically affirming Rich Green in this article. However, he did this without making any effort to find out what the prosecution's experts was saying. And he claims he knows personally Jessica Hyde, but he still didn't know what her report was. Doesn't sound like he reached out to her. I mean, you're going to comment for Vanity Fair in a murder case. If you ask me, you have a responsibility to try to see what the arguments were on both sides. If you're told that the prosecution has independent experts who have an explanation for why this timestamp is not the time of the search, you ought to at least find out what it is. He didn't. It says he noted that Green additionally verified the search times with associated wall files that are occasionally overlooked. So this is interesting. So that to me, based on, now that part's not in quotes. So I don't know if that discussion was over the phone or just in a part of the email that she reworded, the writer for Vanity Fair. But why would this guy say that Green additionally verified the search times with associated wall files? So he understood that the prosecution's objection to this was based on the wall files, that they're experts. That's what their experts were explaining. So he had some knowledge of that. And I don't know where he got that, because he claims that he didn't ever look at the testimony before replying here, before giving his answer to Vanity Fair, that he didn't know what the experts were saying. But he must have known something, because he mentioned the wall files here. And he mentioned, oh, well, at least Green talked about the wall files. He's strangely taking, listen, this is what happens. This is what the ARCA guys do, right? Somebody calls you up and they're nice on the phone and we need you to do this. You're going to try to give them what they want. I don't know if that's just human nature. I don't know if it's to want to be written about in an article. In the case of the ARCA guys, to please your master, they could tell that Josh Levy was looking to dispute. But there's a lack of ethics here to stand back and look at the stakes of what's involved and make a careful effort to get to the truth. The ARCA guys definitely didn't do that. And I'm not saying he's a bad guy, but this guy, Umit, didn't do it either. And he is communicating with Tuesday, and she's going to have a future article on this. So we'll let her work that out. But it looks like he is reversing, at least partly. He has since watched Ian Whiffin's testimony and says that might be accurate. He said, looks to be more or less accurate, with the qualifying exception that, well, it's possible that Ian Whiffin had a different version of the Apple operating system. And so maybe that doesn't fully nail down what the problem was here. But he's definitely backtracked quite a bit from what he's saying here in this article. But that'll be look for Tuesday, and she will get to the bottom of this. But it looks like he's reversed this. Gotta say thank you to a couple people. So all kinds of music check. Well, thank you very much. All kinds of music check. And in my bar owning days, we kind of ended up with a very unique formula for music that we were the first bar playing it off a computer. And we played a really unique kind of mix once it got crowded, and to get the crowd to build an incredible energy level. I mean, it would be the end of the night. Everybody would be raise their hands, singing, screaming, and not wanting it to end. That's how it would be at 2 a.m. Well, at quarter of 2 a.m. And then we would turn off the music, turn off the lights, and start getting people out. We played rock, but the kind of rock that people could sing, and we played dance, hip hop kind of stuff, the high energy versions of it. The idea was to just keep building the energy. And when I say rock, I mean, it could have been Neil Diamond. We were one of the original places doing that. Sweet Caroline, stuff that people can sing to. So I don't know if Sweet Caroline is considered rock, but anything from that to Friends in Low Places from Garth Brooks, AC/DC, Shook Me All Night Long, Def Leppard. There was kind of a formula for it. We'd mix it up every night. But anyways, all kinds of music we did play. Garth Brooks, so we even played some country music in that. But she said that she appreciates what we do here, and we appreciate having you here. So thank you very much. And Dreamboat Annie gifted 5 Yellow Cottage Tales memberships. Thank you very much. And if you're wondering what people get for that, it's pretty much nothing. I hate to say. So you're basically, if you're getting the membership, it's just to support me. I think it's like $1.99 or might be $2.99. I forget. I have never figured out a way to give somebody any kind of special content for joining up, other than to say thank you. Maybe now Turtle Boy does like Turtle Chat on Thursdays. I just don't know. I would do that. I just don't know if there's enough. He's huge. He's got numbers. So I don't know what he gets in his private Turtle Chat, but it's probably still in the hundreds. I'm afraid that if we did a private Yellow Cottage Tales club, there might only be 10 or 15 people. So I can still do it. I don't mind doing it. Yes. And obviously, if you become a member. You get to join the Discord and have some conversations with us there. So the conversations are a little bit more focused and small numbers. Really smart people there. So it's been very good. My good friend Pat, the O'Keefes and witnesses should be feeling really good this time around. I think the tide has turned, but looking at this mistake, if it's a mistake, if this is accurate by Burgess, it's worrying, right? And you worry about what other mistakes are going to happen. It does seem like we have, by all reputation and by everybody on all sides, seems to say that Brennan is a superb lawyer. So that gives us a lot more confidence that they'll have a more thorough strategy. He doesn't want to end up with egg on his face. So that gives us a lot more confidence. And the evidence is there. And now, look, even if Lally was doing this trial again, he'd do a 10 times better job because he gets to learn from the mistakes of the first trial. And that's important. He did have to pull off an enormous task by himself. A lot of witnesses, a lot of technical stuff. Thank you, Ashley. Thank you, Heather. And thank you, Ashley. And hello, Heather. If your mom is listening, hello, Mom. Mrs. Heather Ann. Heather says that Brennan is one of the best in the country. And Heather was a practicing lawyer in this state, so she knows. So that's what we're hearing. So hopefully it's true. Ken Weeks says it's amazing. 9 jurors voted guilty for manslaughter with all of the mistakes. Yeah, it really should be a layup. I mean, the thing is really, if they just explained the injuries and they did the correlation between the vehicle data and John's phone data, that was game over. But the amazing thing is, so all this information that I present about that correlation, it comes from the trial. I don't have any investigators out there. It's coming from the trial and from the documents related to the trial. That's it. That's all where I get my GPS data and stuff like that. I'm not making it up. I'm not doing, I'm not sending out private investigators to look into this. So they just had to put it together and present it, but it really is slam dunk. This is the thing that people don't the GPS showing that John's phone never went in the house. And they try to confuse people by saying, by presenting other data. This is why I said too, you will come to forks in the road and you have to take it. You have to take one of them, logically, right? So there's one there. Do we want to believe the GPS data, which says that John's phone never went in the house? Or do we want to accept the health app data, which says you went up and down 3 flights of stairs and walked 116 steps? Which of those data is more reliable? Which is the least likely? And you can't just sit there and say, well, I'm confused. Why do I accept either data? So I'm not going to accept any data. Listen, not all data is equal. GPS is very reliable location data. And its degree of unreliability is always known from second to second because it's based on the strength signal of the satellite signal, which is, they always have that. It's always in the record. Your health app is interpreting a variety of data on your phone. It's trying to figure out what you're doing. It's always going to be imperfect. It's not designed. The GPS was designed to fly a missile through a mullah's window 1,000 miles away over the horizon. Your health app was designed to help you jog. So they're not the same. So when you come to that road, either I've got to accept the health app data or I've got to accept the GPS. You accept the GPS. Not because of bias, but because it's just the better data. It's much better, much more reliable information. And it turns out we can easily explain why a health app, there are different ways to trick a health app. Now, we don't know for certain in this case here, but if you look at where they were on, I forget the name of the street where they were at, where they first began the health app suggesting that he was going up and down stairs. The difference in elevation between that location and Fairview is about 3 stories. In addition, I found on a hunch, if the car was so it takes about 8 minutes for a car to warm up when it's 18 degrees out. And that's more or less exactly where they were when John's health app started showing him going up and down stairs, supposedly. So they blasted the heat at that location to warm up the car about 8 minutes into their journey. And that would have changed the pressure inside the car, the equivalent of 3 flights of stairs. And that's what the Apple phone uses, is basically an altimeter to detect changes in pressure. So a change in pressure like that at the interior of the car will be interpreted by a change in elevation. In other words, stairs. And then you look at other things like speed. So my theory is that we also looked at the average speed of the trip between when they first put in to Waze, that was over on Dedham Street, and to where they traveled to Fairview. And I don't have the numbers in front of me, but the average speed was pretty low. And it doesn't seem like Karen's the type that drives slow. I forget. I don't want to throw the number out because I don't remember. I had calculated it before, plugged that data in, but it was low, and it suggested they were driving slow. And that doesn't seem like she would be the one to do that. However, it's an average speed. So if you stopped somewhere for, say, 20 seconds, then that would end up with a lower speed. Even if you were driving 30 miles an hour, that would end up with a lower average speed for your total journey. And so I believe after Waze directed them around and they were coming on the turn from, I forget the street's name, to go onto Cedar Crest, you would take a right to go to Fairview, or you would take a left to go back to Dedham Street. And my guess is that Karen, we'll see if hopefully they get this GPS data out, this new data, because from the vehicle, because that would really show. If I hit that guess right, I'll be pretty proud of that. But I believe they stopped at that intersection and Waze is telling them to go right, but Karen wanted to go left to go home because she didn't want to go to the party. And so they probably stopped there for 20 seconds. And that would be enough to slow off the average speed. And so all of that kind of stuff could lead the health app to be confused into thinking someone was walking. But, who knows? In any case, GPS is not the kind of data you can mess around with. It is what it is. And John's phone never went inside the house. And it was found underneath his body near the property line, which is about 80 feet from the driveway. You can't get around those things. You have to incorporate that stuff into whatever theory you want to propose here. And I cannot think of any theory where Karen watches John walk into the house and then accounts for the phone being at the edge of the property, unless John left the phone on the seat and 5-6 seconds into it, Karen drove to the edge of the property, rolled down the window, and threw John's phone into the yard. Maybe that could explain how the phone got there, right? But among the problems with that is that Karen never said that she did that. And then another problem would be John was found on top of his phone. So that would mean the killers took him out of the house later on. Now, could they find the phone in the yard? Yes, if they were calling it. But they would have had no reason to know that he was missing his phone. I mean, they didn't find the phone on him, but they would have no reason to think the phone was in the yard. So they wouldn't have done that. So I guess you'd have to assume that they called John's phone and just by random luck saw it light up in the yard and they said, oh my God, the phone's over near the edge of the yard, all the way down near the property line, and they just happen to see that, and they say, "Let's go put the body on top of the phone." None of that makes sense. But that's literally the only direction you can go. There's just nowhere else to go. And this is the problem with these free Karen Read people. They ignore all of those logic questions. They say, let's just ignore it. All right, we'll take on a few questions and then call it a night. I missed the Celtics game tonight. That sucks. Hopefully they won. They might even still be playing if they're like in overtime or something, but they played the Nets tonight. I don't really like to miss Celtics games. So Gene is going over things like let's put Gene's comment up. I wouldn't doubt if those scratches on the arm, I assume, are somehow related to glass smashing in the hand during the impact of the car. I personally think his head could have hit by the fire hydrant. So, we played with all these theories for about a year. Did it hit the fire hydrant? Did it hit the electrical box? Did it hit a rock on the ground? Those are all things that we played with. And there were problems kind of with all of them. So the best explanation seems to be what the state has, that he hit his head on the frozen ground. Because if he hit his head on the fire hydrant, how did he end up where he was with his phone underneath him and with the cocktail glass lying right next to him? That has to be explained, right? So it seems not certain, but somewhat clear that the impact certainly the impact to the head injury crushed multiple bones in his skull, and it probably rendered him unconscious more or less immediately. And certainly incapacitated. That's what the medical examiner said. Couldn't say with certainty, but hi, Sunny Spirit. I checked into, the Celtics are in overtime. Oh, thanks, Pat. I checked into your show today. You had good numbers. Good to see you. Jennifer says it's really hard to know what happened. We may never know, but that's a problem. The state has to be able to know quite a bit of this. If they don't have a reasonable explanation as to how the injuries were caused and the damage to the car, they may not have to explain every single scratch, but they have to have a pretty plausible explanation of that's reasonable doubt. So that'll be very unfortunate if they can't come up, even though there's still a lot of other powerful evidence like data and stuff like that. If they really can't explain the injuries or how he ended up where he did, that's going to be a problem. Let's just be honest. It is. You got to be able to, that's fundamental. This was the problem with the state's case. With all this talk about John spinning and, that was just confusing to any normal jury. That's a problem. You confuse the jury. That's reasonable doubt. Yes, we covered the motion. You mean the original Burgess motion from a couple weeks ago? Yes, we covered that then. Yep. Thank you, Rogue. And I'm sure you've seen that you were made famous by the messages that Sean released. Heather says, I think the state will benefit from having a strong expert. Yep. So, we'll have to wait till we see it though, right? See what the explanation is. I personally think, and Kara here, I don't know if Kara's here tonight, she's done a good job of explaining how if the arm was bent like this, if you look at the plastic pieces that are part of the taillight housing, once you remove the plastic off, those pieces are exposed. And there's even kind of like a prong that comes out, that if your arm is like this and it's crushed like that, I think that those pieces caused those scratches. But I don't know. It wasn't explained at trial. So that's Kara's explanation. I like it, but I don't. But the state didn't give us an explanation. So you're left to wonder: was it broken pieces of glass, cocktail glass, that somehow it smashed? But no glass was found in the wound. So I mean, I like Kara's explanation better. So Gene says that his dad was a victim of that too. Sorry to hear that. I hope he lived. But that one sneaker was found 30 feet away. Yeah, this is common for these things. But again, you have to explain all of the injuries. We can explain the missing sneaker. What we can't explain is the arm injuries and the lack of injuries anywhere else. That's the issue. Oh, and thank you, Joe. Appreciate it. And 235 watchers on YouTube and only 141 on X right now, and only one on Facebook. But thank you guys for being here. Friday nights are a tough night to get numbers. These are good numbers for me. It's good to have you guys here, and people will go and watch it over the next 24 hours. So they do see, which the chat usually replays, so they'll see your comments in chat and they'll hear what we have to say. But thank you. Appreciate it. Thank you guys for being here. And I will be, I think, back Sunday night. So Karen McCormick wants to do a show, and we're actually going to go over. I did Court TV a few days ago, and they wanted to go over the Vanity Fair article. And when I did it with Karen last week, I just kind of had skimmed through it. But for the Court TV thing, I read it and highlighted. And there were actually a lot of interesting things in there that I hadn't caught when I was skimming through it. So me and Karen are going to go through that. For instance, I didn't even catch somehow in the first reading that Vanity Fair spoke to a juror. Now, who is that juror? There's been 3 jurors there's been 2 jurors and the dismissed juror that have been in communication with Turtle Boy, at least. We don't know. There could be more, but at least those 3. So that juror that Vanity Fair spoke to, based on those comments, I think actually is the dismissed juror. She's a turtle rider. That's confirmed. That's not why she's dismissed. Not the only reason, but she wasn't honest with the jury questionnaire and was not honest every day when you have to take the oath and say, do you swear that you have not followed this in the media? So this is something they have to be aware of in the next trial. It's very important. Any comments on the whole Aiden Sean meltdown? I did see that Young Jelly was very mad at me, blaming me for flipping Sean and stuff like that. It's not really how it went down. So the way it went down was, I have in the past discussed with Karen McCormick how to flip Sean, because I believed he could be flipped, because I do think he's being eaten up inside by some of what he's done in the last year. Let's just be honest about it. And I think he started out with good intentions. At some point, realized he was being duped and just couldn't deal with it. And I believed, and I had a strategy with Karen. This was like, say, 3 months ago. And then we put it aside. We let it go. We just said, you know what? I got too much else to do. And it seemed too unlikely. And then a couple of Sundays ago, so not even I don't even think it's 2 weeks ago yet. I think it'll be 2 weeks from this coming Sunday. He put up a really vicious claim about me. Not even anything specific, just like implied, So I called and left him an angry message. We exchanged a bunch of texts over the next 24 hours, but he put up a show that was intended to destroy me. That was the thumbnail and everything. But I put on I didn't really watch the show, but I put it on. It was long, and I don't know, maybe an hour and a half into it for a few minutes. And I was worried about Sean because he looked red in the face and angry. And I'm like, I don't want something to happen to the guy, And because I did spend a lot of time talking to Sean a couple of years ago and liked him a lot. So I just, even though, I don't know, I didn't really obviously I was angry about the stuff that he had said, but I just didn't want to see something happen to him. And so I kind of texted something joking during the show, and he texted back. And so we tried to make a light moment about it, but I just wanted him to take it easy so he wouldn't have a health crisis on the show. And over the next week, we were texting and emailing, and but I did talk to various people and say, I think now's the time to maybe flip him. But again, it's not about brainwashing someone. It's about just telling them to tell the truth, appealing to their better nature and say, look, we know you want to tell the truth. We know you don't want to be that guy that is accusing innocent people completely without any evidence of being parts of conspiracies like Paul or Mr. O'Keefe. Even, I mean, it was just getting absurd. And so, but we believed there was enough decency and goodness in Sean that he could be flipped. Not just me, but other people that I talked to and enlisted to help. Karen, Colin Forrester, and eventually I talked Kate into it. I said, I think he might have some material here that might be interesting, and I think he could be flipped. And so Kate decided, yeah, okay. And so he agreed to go on her show. So that's all that happened with that. And we just want him to do the right thing. And so maybe me and Karen can talk about more about that. But as far as the war between him and Turtle Boy, I don't look at it like a divide and conquer thing. I just look at it, it's the war of decency versus indecency. And I want decency to prevail. Anybody with even just borderline decency understands that Turtle's tactics are indecent. Turtle's tactics of just a few weeks ago saying he's going to bring his mob to the soccer game of the Attorney General's kids. If you don't understand, if someone needs me to tell them that that's indecent, then they're just not decent, and they're never going to know any better. They're not capable of decency. But I think there are people like Sean that understood, yeah, that's not decent. So you have to just appeal to that side of them and hope that in that little internal war that goes on sometimes within each of us, that you can appeal to that side and can win. So Peter, as a question, Kevin, you are an ex-bar manager and bar owner. What's your thoughts about Higgins' behavior in the bar? Which part, though? So you mean as far as when he was play fighting with Brian? It's shit that goes on in a bar, you know? I've had to jump the bar and break up 1,000 fights. And if you jump the bar and you find yourself in the middle of Brian Higgins and Brian Albert, that's a fucking bad night. Let me tell you. But I did have a lot of bad nights like that. And that's when you just got to try to outsmart them. You got to try to, or maybe outsmart them is not the right word. Use an appeal within them that there's something. Now they were just horsing around, but if two guys like that were about to get in a real fight, you try to use your head to find a way out of it without getting killed and without anybody else getting hurt. So Thomas Fleming has been there with me at my side many times. And, knowing your weaknesses, I guess, is the key. If you know you're not someone that's going to kick ass on guys like that, and there were no shortage of guys like that in the bar, in that situation, there was no reason to jump the bar there. That was just two guys horsing around. I would have glanced over, seen they were friendly with each other, and said, all right, I'll keep it like not in that situation there because they all knew each other and there wasn't really anybody else in the bar. But if I saw those two guys doing that and the place was jumping, it was packed, I'd keep an eye on them and I would look at my doorman. Actually, we would have multiple doormen at Leitrim's, and we were great at communicating silently with each other. And so once I caught their attention, I'd look, they would look, and they would know. So and they were taught different ways to handle it. One way is just to go in and just say, hey, how you guys doing? Just be friendly. Remind them, though, that you're there. And, there's different ways to handle it. But the main thing is usually most people are decent and you're appealing to that side of them, or at least there's going to be someone decent in a situation like that. And say, hey, dude, just calm down. But one of the tricks was it was loud in there, the music. But even if it wasn't that loud, I'd say, hey, listen, man, I'm a little hard of hearing. I want to talk to you. Can I talk to you at the door? And this was also a way of separating people from their friends, because usually it's 4 or 5, 6 guys together in a group, and usually it's one of them that's the main combatant. You get him over, and by saying something like that and saying, "Hey, man, I'd like to talk." Usually they're like, "Oh, okay, I'll talk to you." Now you get him to the door, and you step outside, and you talk to him, but you don't let him back in. And the look in their face will be funny. They'd be looking around like, "Ah, shit, he's just separated me from my friends. He's got me out the door. I'm at a very big disadvantage." If you didn't trick him to the door, though, that guy would have been a nightmare to get out. So that was just one of the tricks that you try to do. If you're not Brian Albert or Brian Higgins, so if Brian Albert or Brian Higgins were in my shoes as the bartender, they wouldn't have had to learn those tricks, because they're tough enough that they can handle some pretty big. But that said, Brian Albert, I don't know about Higgins. He does undercover work, right? But certainly Brian Albert, dealing with guys with guns and stuff like that I'm sure they have their own tricks. Even though I'm sure he's as tough as they come, he doesn't want to get stabbed, doesn't want to get shot. So you learn to do tricks, and I'm sure they teach tricks in his job, and I'm sure he has his own tricks that he learned that served him well over the years. And I had to learn my own tricks. But necessity is the mother of all inventions, right? So because I was kind of thin, so when I first started bartending at the Blarney Stone, I was same height, 6'2", but I had just come off a period of illness. I was 21, and I was only 167 pounds. I had been like 180, 185, but I had just had mono and bronchitis, so I had lost a lot of weight. And so when I jump over the bar to break up fights, I was definitely the skinny dude. So you just got to learn how to use your head. I don't know how the hell I survived all those years without getting killed. But just luck. Karen called JJ repeatedly because she didn't know. Well, interesting too is Karen. It was interesting to see the pattern that Karen was calling John repeatedly during the early afternoon because of the fight they had been in. You could see he was sometimes not taking the messages, not taking the calls. He had that kind of like, oh, Jesus, this girl won't leave me alone. She was wearing him out, but she's one of those people that if she's bugged out, she's just going to keep calling and calling and calling and calling and messaging until she gets what she wants. So, so it made it seem a little less unusual that she did it late at night. It seems like that's just, well, look, as a guy, we've all been in relationships where you have a girlfriend that does that. I'm sure vice versa. I'm sure you girls, ladies out there have probably had a boyfriend that did that too. I'm not trying to say that that's a female characteristic. So we've all been in relationships where the other person can be, if they're upset, a little obsessive and they make a lot of calls. That may have been why John was thinking that relationship had run its course. He may have been sick of shit like that. So, but don't know. Why invite John to the house with the purpose of beating him up? Yeah, makes no sense. Makes no sense. You're inviting him into a house where your son on his birthday stayed home because he had anxiety issues. He's a big dude, don't get me wrong, super big dude. But I don't think beating someone up, a Boston cop in the house, was going to help his anxiety issues. You have your wife there. You have Jen McCabe there. You have your daughter there. Your daughter doesn't live there. So if you know you're going to go back to beat this guy up, you're going to tell your daughter, just go home tonight. We got some shit going down. So it just doesn't, none of it makes sense. At every point of this story, the conspiracy theory does not make sense. And it's crazy that people don't ever, on the other side, ever go down any of those paths. But, all right. So the Celtics pulled it out. Good. Thank you. Excellent. Kate, let me know how Kata did tonight. Kata's been one of my new favorite players. That's exactly what they needed. And he's been awesome. He's the missing piece. So when I say missing piece, they did win the championship last year, but There was a nurse there too. That's right. Well, when they invited him back, they couldn't have known that. But Sarah Levinson and Julie Nagel, Sarah Levinson's a nurse. So yeah, they're inviting John back to beat him up, even though not only is Brian Jr. there with an anxiety thing, but he's having a party. It's his birthday party. He's got people there. It's crazy. Thank you, JI5. Appreciate it. But none of the theory makes sense. But what happens is people get lost on the things that seem strange to them. So why didn't the Alberts come out of the house? Maybe the butt dials. But those things really don't amount to anything. The only thing that really matters is explaining John's injuries. When we first heard the story, the fact that they didn't come out of the house was the thing that maybe bothered me the most, and a lot of other people the same way. But over time, when you realize, no, so somebody sent me the weather report recently, a couple of weeks ago, for that the detailed weather report for that night, that morning. And so when they found John O'Keefe, it was sustained 30-mile-an-hour winds gusting from 40 to 50. So that's loud. That's going to drown out most noise. And that may even explain why Karen's parents didn't wake up when she called 3 times, 1:15, 4:40, and 4:42, and they didn't wake up. So the wind like that really does kind of put people to sleep. I don't know. Sonny, did Tom visit your show today? I was on the phone with him when I found that you were live, and I said, hey, Tom, Sunny Spirit? She's got a show on. So he's like, oh, okay, cool. I'll go check it out. So he was going to stop by. Yeah, so Jules says men do not wait to fight. They act in the heat of the moment. Well, yeah, most fights, especially bar fights, are just, things that weren't planned. The idea that what the defense is saying is this was not like some bar fight that erupted out of drinking and anger, that this was planned, that this was like a hit, basically. May not have been planning to kill him, but they were planning to rough him up. There's no motive. This is why Karen tried to float this idea that Colin was dealing drugs in the neighborhood. That was bullshit. But they had to have a motive like that, because why would they? Everybody liked John. Why would they plan to bring him back to the house to beat him up? Why wouldn't they just beat him up in the bar? You mean to tell me Brian Albert's never been in a bar fight before? I don't think so. So if you want to rough him up in the bar, rough him up right as he's leaving. I'm old school in the respectable way in the bar business. The respectable way to get into a fight was, let's take it outside, right? Anybody here that's old enough to remember bar things, that's what it said. Hey, take it outside, right? That's what you're even supposed to say as an old-time bartender in the joints back then. Take it outside. So why didn't Brian and Brian wait for him and ambush him outside? They didn't. How do they know that Karen wasn't going to come in with him? They couldn't have. Why? I mean, she was driving. They would have expected her to come in. None of this makes sense. It's really, it bothers me that people even entertain it, because it's like the only way to entertain these theories is to just literally dismiss all questions and logic from your mind. You're so eager to believe it that you just let this go for some reason, to let go common sense questions like that. It worries me. It makes me think that people can convince themselves of almost anything if they really want to. And I guess that's just that's human nature, right? I guess people can actually convince themselves of anything. Hank Brennan is an FBI plant. There won't be a retrial. Mofo, that sounds like Sean. Is that you, Sean? Sean, I think you use that expression, mofo, too. Maybe it's Sean is parodying himself, trying to sound crazy. Yeah, Hank Brennan is an FBI plant. And pretty soon Bohemian Grove is going to step in. And the Rosicrucians and the Illuminati. And I have to say that even back over a year and a half ago when this story first broke and I was entertaining the possibility of a conspiracy here, um, I never bought into the idea. I never bought into the idea that it was Colin. I never would believe a 17-year-old kid is going to attack a cop inside the home of his uncle, which is also a cop. Just wouldn't do it. He just wouldn't do it. And I knew that without knowing any of them. I also never believed that it was planned but it was plausible to me. Bunch of Irish guys drinking, fight breaks out. Shit happens at the end of the night. At the time, that was plausible to me. But that's not what the defense is saying. Good question, Heather Ann. Any thoughts on how the election could shake things up with the federal involvement? Well, Josh Levy is acting U.S. attorney, and he is going to be gone. Now, I think he's glad of that. I said months ago that I believed that Josh Levy was going to quietly leave anyways and go back to the private sector and say, okay, I did my job. I solved Birchmore. I solved the truck licensing thing. And I've done my best to clean up house. And now I'm going back to the private sector, ropes and gray. But he won't even have to leave now because he's just going to be sent out. If he had been approved as U.S. attorney, that might be a longer and harder process to get rid of him. There are some issues with that. But the fact that he's acting, all it means is Trump has to appoint someone else, and they'll be acting until they're approved. That's my understanding of it anyways. So yeah, Levy is gone. Now, question is, is there a house cleaning? Is there an actual investigation? Because there does clearly seem to have been, at the very least, highly inappropriate and irregular behavior going on between Josh Levy and Karen's team. That's beyond dispute. Was there something improper? Was there something corrupt? Was there something illegal going on? That we don't know, but there needs to be an investigation. Did Ropes and Gray file an amicus brief? I didn't hear that in the case. Not that I know of. Maybe you know something. You might know more than me on stuff like that, but I not that I know of, Heather. When the defense shows Colin as a ring bearer 10 years ago, that's incriminating. I think you're probably being sarcastic, right, WD? But I mean, none of that shows. All they ever showed was a potential connection between Proctor and the Alberts that might be good to get a speeding ticket fixed, and that's about it. But it's not about whether there was. This is one of the rules that I've tried to draw up, and you at home might find this useful. It's not about so when you're looking at trying to figure out the actions of criminals, of potential criminals, of corrupt investigators, whatever. It's all about means and motive, right? That's what we always hear. Well, that's true, but let's add a little. Let's expand on that. It's not about motive. It's about sufficient motive. So you look at Michael Proctor. This isn't a matter of him looking the other way while something goes on. They would have asked him, if the defense theory is true, to plant evidence. Highly risky thing to do in that situation where you're talking about planting it 16 hours after the event. So on a street surrounded by other troopers, the CERT team, his boss, Lieutenant Tully. In a situation where you couldn't know if Karen, for instance, or her brother had taken a picture of the taillight. Highly risky, highly likely to be exposed. And if you're exposed, the penalty is extremely high. You're talking about going to jail, losing your job, destruction of your family. So that's why I say it's about sufficient motive. Was there sufficient motive for him to do something that he was highly likely to get caught in, and that when he was caught was going to pay an extremely high price for? That's what I mean by sufficient motive. So in any case where you're looking at here, when you're trying to wonder if they did something like that, you have to ask yourself, was there sufficient motive? Tom, was that the question about the title of the book? So let me just stretch for a second. Ugh. I have some issues that result in I get stiff. I'm sitting for a while. Anyways, so the title that I want to go with is A Perfect Storm, the Karen Reed trial. The publisher hasn't approved it yet because he's a little bit worried about the Perfect Storm, the movie and the book. So, but that's the one that I really want to push. I wouldn't want to go with A Perfect Storm. It has to be A Perfect Storm, the Karen Reed trial. So it's all together in large print. I don't mean so it won't be A Perfect Storm in the Karen Reed trial. It's just kind of a subtitle. No, it's all one thing. A Perfect Storm, the Karen Reed title. That's what I want to go with. If the publisher doesn't approve that title, I'm not sure. One of the titles that someone else had suggested, which I'm not sure I like anymore because it's not clear, but It's Only a Movie, which is something that John was known to say and Paul remembers him by. Another idea that I had was to call it American Evil. I don't know what you guys think about that, because the title American Evil opens up the possibility to a sequel. A sequel that involves a different case. But we don't know. You can also treat it as in kind of a both sides kind of way. So American Evil. Well, if you think there's a conspiracy here, that's the evil. If you're looking at Karen's actions as a murderer, that's the evil. Or if you're looking at the mob that was stirred up, that has really been the most defining aspect of this case, and the cruelty of that mob, the mindlessness of that mob. This is one of the more, a theme of mine is that, what's that old expression? All that's required for evil is for good people to stand aside and do nothing, something to that effect. But, so Cheryl likes it. Okay, good. Thanks, Cheryl. This kind of I want to rephrase that a little bit for the purposes here, or my understanding of it too. It's not just, evil doesn't just require good people to stand aside and do nothing. Evil, actually in this case here, requires a level of participation by otherwise good people. That's one of the lessons of this case here for me. A lot of those people that are out there with the pink shirt armies, most of those people are mostly good people. But now, for them sticking up for Karen is not evil. I don't mean that at all. But them cheering Turtle Boy and giving money to Turtle Boy when he is behaving the way he does, threatening people, threatening to destroy people, spreading false smear about people. Look what he's doing to Phelps. Now he's trying to suggest that Phelps is a murderer, that Phelps murdered, what was it, his sister or his sister-in-law or something? I don't know the whole story, but he's trying to suggest that Phelps, just because he doesn't like the way Phelps is reporting on this story, he's now going to look for ways to destroy Phelps. And if he can't find something real in his background, he'll go all the way back to the 6th grade and see if he stole some kid's lunch money. If you can't find that, they'll make it up. That's what the pit bull does. That's her main purpose. But he has other people that do that with him. They find something in the background that they can take and manipulate. And so it's true evil. And it's the kind of thing that anybody that participates in that mob, if they weren't within the mob, if you pointed that activity out to them, but said, this is happening in another state, this is happening over in Georgia, where people are trying to smear innocent people by digging for dirt, and they're threatening to go to the kids' soccer games with the attorney general. Most of the people that follow Turtle Boy, I think, would see and they'd say, that's evil. But something blinds them here and they don't see it. And this is the problem. This is why I say this is strange. Tom, wasn't there a book called The Banality of Evil? That sounds familiar to me too. Or maybe that's just a quote. I don't remember. Maybe it was a quote, The Banality of Evil. But I think this is a factor here where otherwise more or less decent people, not perfect, but none of us is perfect, are doing something evil. They're participating in an evil process. And I don't say that because I think Karen's guilty. I say that because of the tactics they use. I say that because they aren't interested in actually getting to the truth. They've sold themselves on a narrative and they feel good about themselves because they're part of this thing and they're no longer interested in the truth. And you can't get through to them. They've shut their minds down. You can't show them the GPS. They won't even look at it. No, I don't want to see it. I don't want to see it. I don't want to see it. You can't show them the actual evidence. They don't want to see it. So it becomes pointless to try to show it to them. You can lead a horse to water. You can't make it drink, right? That's the old cliche. That's how it was when I grew up. I'm kidding. There was no horse where I grew up. Of Evil was a quote from Hannah Arendt, a popular author referring to Nazis, of course. All right. I remember that. I had that in my mind. Thank you, Thomas. I knew that was an expression or something, or a famous quote or a book, The Banality of Evil. And it's worse than people know. And there's some aspects of it I can't talk about, but it's deep, it's disturbing, it's dark, it's true evil. It really is. And as a society, we have to stand up to it, each doing what we can. I'm not saying everybody has to go out there and make themselves prominent and withstand those social media attacks, but everybody has to do what they can, whatever in your conscience you think is within your power to do and you think is fair to do. Everybody has to do it. There's no way around it. I have kind of believed that if we fought indecency with decency, as I said at the start, then in the end we'd win. But who knows, right? I mean, we never really know. I want to bring up something to show you guys, and maybe this will just close with this. Hold on 1 second. I got to find this clip here, just a short clip. Someone had asked me if I'm going to do a reaction show to Sean. No, I don't want to beat up on him anymore. I want him to have good health. Maybe he can still come around and do productive things. He's likable. He's an articulate guy. He's got some experience in law enforcement. So all right. Let me turn so you don't get any feedback. I like to give people, I like to look at these inspirational speeches or movie moments. So let me give you guys this one.
The young filmmakers, actors, singers, writers, producers that are coming up behind my generation. In particular, Barry Jenkins. Young people understand this young man made 10, 15, 20 short films before he got the opportunity to make Moonlight. So never give up. Without commitment, you'll never start. But more importantly, without consistency, you'll never finish. It's not easy. If it was easy, there'd be no Kerry Washington. If it was easy, there'd be no Taraji Henson, P. Henson. If it were easy, there'd be no Octavia Spencer. But not only that, if it were easy, there'd be no Viola Davis. If it were easy, there'd be no Michael T. Williamson, no Stephen McKinley Henderson, no Russell Hornsby. If it were easy, there'd be no Denzel Washington. So keep working, keep striving, never give up, fall down 7 times, get up 8. Ease is a greater threat to progress than hardship. Ease is a greater threat to progress than hardship. So keep moving, keep growing, keep learning. See you at work.
I hope you guys enjoyed that. I'll give you one more quick one. This is another one that I found. I don't even know what movie this is from, but it had some good. It had a good insight moment in it.
People are calling this one of the most unlikely comebacks in sports history. What do you attribute it to?
Yeah, I don't know. I had a lot of help.
But you've also had a lot of adversity. You've had issues with management, conflicts of interest.
Yeah, well, the boxing world looks shiny from the outside. It's filled with promises that most of them turn out to be lies. You can't rely on anyone.
So what would you say the biggest deception was? What was the biggest lie you were told?
It's not that simple.
Why not?
No, that's the biggest lie I was ever told. It's not that simple. And it's a lie they tell you over and over again.
What's not simple?
Any of it. All of it. It's how they get you to give up. They say it's not that simple anymore.
So what's the truth?
That it is. That if you just do the thing that they tell you you can't, then it's done. And you realize it is that simple. And that it always was.
Okay, I don't even know what movie that was from, but it was kind of a cool thing there because I've encountered that a lot too over the last year when I never have pressured anybody to try to stand up and do the right thing here. But sometimes people have said to me, even though I haven't pressured them, well, I know it's the right thing to do, Kev, but it's not that simple. And so they don't do it. But, maybe sometimes some things are simple. Doing the right thing is simple. Doing the right thing is not complicated. Doing the right thing is not easy because if it was easy, it's worthless. It's only when doing the right thing is difficult, where there is a price to pay, that you really showed that you have the kind of character that you're committed to doing the right thing. And I think we all have that in us. And most of us, if we want to, will find that. Okay, guys, have a good night. And I think I will see you Sunday.